So, a pleasant afternoon to each and everyone. So, the topic that I'm going to discuss today is all about Title 5 bylaws. So, what are bylaws? So, bylaws signifies the rules and regulations or private laws enacted by the corporations to regulate, govern, and control its own actions, affairs, and concern, and its stockholders or members and directors and officers with relation thereto and among themselves in their relation to it. So in other words, bylaws are relatively permanent and continuing rules of action, right and duties of corporate officers and directors, trustees or stockholders or members toward the corporation. So, yung bylaws po, kasi yun yung mga rules, ordinances, regulations, or laws adopted by an association or corporation for its internal governance. So, pag sinabi po natin internal governance, included po dito yung calling meetings, how long it takes para makapagbigay ng mga notice for stockholders. So, what are the purpose of bylaws? So, the purpose of a bylaw is to regulate the conduct and define the duties of the members towards the corporation and among themselves. So, yung bylaws, siya yung nagre-regulate ng mga transaction of the business of the corporation. So, yung bylaws, pwede siyang self-imposed, although ina-adapt niya pa rin yung ating public law. So, next is, are third person bound by bylaws? So, it is generally accepted rule that third persons are not bound by bylaws except when they have actual knowledge on the provisions either actually or constructively. So, as a general rule, yung third persons, hindi sila bound ng bylaws. So, hindi necessary na kailangan nilang mag-investigate sa nilalaman ng bylaws ng isang corporation except when they have the actual knowledge on the provisions of bylaws either actually or constructively. So, bylaws are subordinate to the articles of incorporation. So, bylaws may be necessary for the government of the corporation, but these are subordinate to the articles of incorporation as well as to the corporation code and related statutes. So, there are cases where bylaws are unnecessary to corporate existence or to valid exercise of corporate power. Kasi po, yung corporation existence begins at the time na in-issue yung Certificate of Incorporation ng SEC. So, pero tandaan din natin na yes, may existence na si corporation at may valid exercise of corporate powers na yung kanyang mga board of directors or yung stockholders. Hindi pa rin po sila prepared to do business transaction since kailangan po nila ng bylaws. So, yung bylaws po kasi yun yung mga internal rules na nag-govern sa management. So, what if si corporation nag-fail siya na mag-file ng kanilang bylaws? So, madi-dissolve ba si company or si corporation? So, even under foregoing express grant of power and authority, there can be no automatic corporate dissolution. So, hindi po basta-basta madi-dissolve si corporation kahit na nag-fail siya to file yung kanilang required na bylaws. Kasi dadaan pa po siya sa process. So, meron tayong proper notice in hearing na gaganapin. So, in this case, si incorporators, binibigyan siya ng chance na explain yung neglect or omissions and yung remedy at the same. So, effect of failure to file bylaws. So, first is liable for revocation of its registration. So, yung revocation of registration, hindi naman po siya basta-bastang ginagawa. So, dumadaan rin po sila sa process. So, gaya nga po ng nabanggit ko kanina, si corporation, makaka-receive siya ng mga notice and dadaan siya sa mga hearing. And next po is suspension. And third is imposition of administrative fines and penalties. So, bylaws are indispensable to corporations, so as the rules and regulation or private laws enacted by the corporation to regulate, govern, and control its own actions, affairs, and concerns, and its stockholders or members and directors and officers with relation thereto, and among themselves in their relation to it, bylaws are indispensable to corporation in this jurisdiction. So, gaya nga po ng nasabi ko kanina, yung bylaws, ayun yung rules and regulations or private laws enacted by the corporation to regulate its own actions, affairs, and concerns. Yung bylaws, hindi naman po siya essential sa birth or existence sa isang corporation, but certainly required siya for orderly governance and management of corporation. So, if nagkaroon man ng failure to file within the period required by bylaws, hindi naman automatic nagkakaroon ng dissolution of a corporation. So, next is effect of substantial compliance with bylaws. So, it should be stressed in this connection that substantial compliance with conditions subsequent will suffice to perfect corporate personality. So, organization and commencement of transaction of corporate business are but conditions subsequent and not prerequisites for acquisition of corporate personality. So, yung adaptation and filing ng bylaws is also a condition subsequent. So, a corporation commencement its corporate existence and juridical personality and is deemed incorporated from the date of the Securities and Exchange Commission's issues certificate of incorporation under its official seal. So next is section 45, adoption of bylaws. So for the adoption of bylaws by the corporation, the affirmative vote of the stockholders representing at least a majority of the outstanding capital stock or at least a majority of the members in case of non-stock corporation shall be necessary. So, yung adaptation daw ng bylaws, kailangan siya ng majority ng stockholders na mayroong outstanding capital stocks or at least a majority members ng isang non-stock corporation. So, the bylaws shall be signed by the stockholders or members voting for them and shall be kept in the principal office of the corporation subject to the inspection of the stockholders or members during the office hours o yung tinatawag nating reasonable hours. So, a copy thereof duly certified by a majority of the directors or trustees and countersigned by the secretary of the corporation by the secretary of the corporation shall be filed with the commission and attached to the original articles of incorporation. So, notwithstanding the provision of the preceding paragraph, bylaws may be adopted and filed prior to incorporation. In such case, such bylaws shall be approved and assigned by all the incorporators and submitted to the commission together with the articles of incorporation. So, yung adopted bylaws daw, kailangan approved and signed siya ng lahat ng incorporators and kailangan din siyang isubmit sa ating SEC kasama nung ating articles of incorporation. So, in all cases, bylaws shall be effective only upon the issuance by the Commission of a certification that the bylaws are in accordance with this code. So, the Commission shall not accept filing the bylaws or any amendment thereto of any banking institutions, building and loan association, trust company, insurance company, public utility, educational institution, or other special corporations governed by special laws, unless accompanied by a certificate of the appropriate government agency to the effect that such bylaws or amendments are in accordance with law. So, adaption of bylaws. So, before incorporation or pre-incorporation, so the bylaws must be signed and approved by all the incorporators and filed with the SEC together with the articles of incorporation. After incorporation or post-incorporation, so the affirmative vote of stockholders representing at least majority of the outstanding capital stock or of at least majority of the members shall be necessary. So the bylaws shall be signed by stockholders or members voting for them. So after incorporation, dito nagkaroon ng changes yung dati pong provision. So, yung dating provision, meron lamang pong 30 days si corporation to file the bylaws after nung issuance ng Certificate of Articles of Incorporation ng SEC. So, sa revised corporation code, inalis na po yung 30 days na palugit for filing ng bylaws. So, ngayon po, hindi na po naka-indicate kung ilang araw po ba ang meron si corporations to file yung kanyang bylaws. So, for additional information, so bakit nga ba kailangan ng adoption ng bylaws? So, first is a matter of practical and legal necessity. Siyempre, sa pamamagitan ng bylaws, nagkakaroon ng power si corporation to act kung ano nga ba yung purpose niya. Dito, nagiging prepare na si corporation to do business matter. So, gaya nga na nasabi ko kanina, yung existence ni corporation, nagsisimula siya by the time na na-issue na yung kanilang Articles of Incorporation ni SEC or ni Securities and Exchange Commission. So, yes, may existence na si corporation but hindi pa siya prepared to do act of business or its purpose. Kasi nga, kailangan natin ng bylaws na kung saan ito yung mag-govern sa kanila. So, kinocompose to ng mga rules and regulations. So, later on, didiscuss ko kung ano nga ba yung content ng bylaws. Also, there are cases or instances na kung saan hindi na nire-require sa isang corporation ang mag-file or mag-adapt ng bylaws tulad na lamang ng corporation sole and one-person corporation since sila ay gina-govern ng ating special laws na kung saan naka-indicate na doon yung mga rules, regulations, and discipline na mag-govern sa kanilang management. So, Articles of Incorporations versus bylaws. So, Articles of Incorporation, it is a condition precedent in the acquisition of corporate existence. So, while bylaws it is a condition subsequent, its absence merely furnishes a ground for the revocation of the franchise or certificate of registration. So, in Articles of Incorporation, it constitutes the charter or fundamental law of the corporation. So, while in bylaws, it is the rules and regulations adopted by the corporation. So, Articles of Incorporation executed before incorporation. While bylaws, it is executed before or after incorporation, like what I've discussed earlier. So, Articles of Incorporation amended by a majority of the Board of Directors or trustees and stockholders representing 2/3 of the outstanding capital stock, 2/3 of the members in case of non-stock corporation. So, while in bylaws, it may be amended by a majority vote of the Board of Directors and majority vote of outstanding capital stock or a majority of the members in non-stock corporation. So, sa Articles of Incorporation, 2/3 lang yung representation para makapag-vote, while in bylaws, kailangan majority. Lahat is laging majority. So, sa Articles of Incorporation, the power to amend or repeal the Articles of Incorporation cannot be delegated by the stockholders or members of directors or trustees. So while bylaws, the power to amend or repeal bylaws or adopt new bylaws may be delegated by the two-thirds of the outstanding capital stock or two-thirds of the members in the case of non-stock corporation. So, yung articles of incorporation, hindi po siya pwedeng baguhin or palitan. While yung bylaws ng isang corporation, open po siya for changes, diba? Pwede po siyang i-repeal or mag-adapt ng bagong bylaws. So, Section 46, Contents of Bylaws. So, a private corporation may provide the following in its bylaws. So, letter A, the time, place, and manner of calling and conducting regular or special meetings of the directors or trustees. Letter B, the time and manner of calling and conducting regular or special meetings and mode of notifying the stockholders or members thereof. Letter C, the required quorum in meetings of stockholders or members and the manner of voting therein. Letter D, the modes by which a stockholder, member, director, or trustees may attend meetings and cast their votes. Letter E, the form for proxies of stockholders and members and the manner of voting them. Letter F, the directors or trustees' qualifications, duties, and responsibilities, and the guidelines for setting the compensation of directors or trustees and officers, and the maximum number of the board representations that an independent director or trustees may have, which shall in no case be more than the number prescribed by the Commission. Letter G, the time for holding the annual election of directors or trustees and the mode or manner of giving notice thereof. Letter H, the manner of election or appointment and the term of office of all officers other than directors or trustees. Letter E, the penalties for violation of the bylaws. And letter J, in the case of stock corporation, the manner of issuing stock certificates. And K, such other matters as may be necessary for the proper or convenient transaction of its good governance and anti-graft and corruption measures. So, Section 47, Amendments of Bylaws. So, a majority of the Board of Directors or Trustees and the owners of at least a majority of the outstanding capital stock or at least a majority of the members of a non-stock corporation at a regular or special meeting duly called for the purpose may amend or repeal the bylaws or adopt new bylaws. So the owners of two-thirds of the outstanding capital stock or two-thirds of the members in a non-stock corporation may delegate to the board of directors or trustees the power to amend or repeal the bylaws or adopt new bylaws, provided that any delegated to the board of directors or trustees to amend or repeal the bylaws or adopt new bylaws shall be considered as revoked whenever stockholders owning or representing a majority of a outstanding capital stock or majority of the members shall so vote at a regular or special meeting. So whenever the bylaws are amended or new bylaws are adopted, the corporation shall file with the Commission such amended or new bylaws and, if applicable, the stockholders or members' resolution authorizing the delegation of the power to amend and or adopt new bylaws duly certified under oath by the corporate secretary and a majority of the directors or trustees. So the amendment or new bylaws only be effective upon the issuance by the Commission of a certification that the same is in accordance with this code and other relevant laws. So, amendment of bylaws. So, general rules. So, the Board of Directors or Trustees by a majority vote thereof and the owners of at least a majority of outstanding capital stock, or at least a majority of the members of a non-stock corporation, at a regular meeting duly called for the purpose, may amend or repeal bylaws or adopt new bylaws. So, exception, the owners of two-thirds of the outstanding capital stock or two-thirds of the members in a non-stock corporation may delegate to the board of directors or trustees the power to amend or repeal any bylaws or adopt new bylaws. So, take note that any power delegated to the board of directors or trustees to amend or repeal any bylaws or adopt new bylaws shall be considered as revoked whenever stockholders owning or representing a majority of the outstanding capital stock or a majority of the members in non-stock corporation shall also vote at a regular or special meeting. So, sinasabi dito na yung power na dinelegate ng mga board of directors sa mga board of directors or trustees na to amend or i-repeal or mag-adapt ng new bylaws ay makukonsidered na revoke when yung mga representative na mayroong majority of outstanding capital stock or majority of the members in non-stock corporation ay bumoto din sa kanilang regular or special meeting. So, also, the amendment or new bylaws shall also only be effective upon the issuance by the SEC of a certification that the same in accordance with a revised corporation code and other relevant laws. So, binding effects of the bylaws. So, number 1, as to directors or trustees, officers, and stockholders or members. So, as to directors or trustees, officers, they are bound and must comply because they are presumed to know the provisions of bylaws, while as to third person, they are not bound unless they have knowledge of the bylaws. Additional information on the binding effects of as to corporate directors or trustees, officers, and stockholders or members, so binding not only upon the corporation but also on its stockholders, members, and those having direction, management, and control of its affairs. Also, they have the force of contract between stockholders and members. So, as to third person naman, not binding unless there is an actual knowledge, like what I said earlier. So, the third person are not even bound to investigate the content because they are not bound to know the bylaws, which are merely provisions for the government of a corporation, and notice to them will not be presumed. So, that's all. Thank you for listening.